Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye. Jen says, well, to start, the federal judge looked at the ALJ decision. Okay. The federal judge looked at the ALJ decision and asked my lawyers, why did the ALJ do this and this? And we're like, you tell us. So they had a hearing. It was on, usually it goes on papers. So are you sure that happened, Jen? Well, think about it. Every judge in every area of law is a person that has to make a judgment call. And actually, if you think about it, people in general, we all have to make judgment calls. And how many times have you made a wrong judgment call? With all the evidence you had, we all have. And I would imagine that would happen with judges too. There are probably far less mistakes than what we have because they're trained specifically in this specific area. And, you'd think they would know. Whereas we're flying by the seat of our pants with, different situations all through life that we have to bounce back to, right? We have to address and all that good stuff. So I don't know how it is imperfect, but only because life is imperfect. Right? We're all imperfect. I make bad judgment calls sometimes. And I'm like, shoot, I would have gone the other way. If I saw it the way I see it now, if I saw it that way then, we're just human. So I look at that a lot, and the law it's not able to, it's just an organized structure of criteria and rules, and no set of such is ever going to catch everything, I don't think. If you're going to catch everything, then you have to get rid of the rules and just give everybody the SSD or the SSI, the award. You know what I mean? So I look at it kind of like that. That's not to say your judge didn't screw up. And in fact, you'll probably find out when it gets remanded that he did. And it was one of the ones where he actually did a poor job. And that's why it's remanded. But I don't know that we can get a more perfect system if we're going to keep a system alive, I guess. It's almost like, by analogy, you don't want to risk your kid getting hurt, so you never let him out of the house. Well, he's not going to get hurt. You don't want to risk your kid getting hurt outside, so you never let him out of the house. Well, you're going to succeed. He's not going to get hurt outside. But is the damage done by the other total safety net, not more damaging and a bigger loss? I don't know. But that's kind of how I look at it. You got to just kind of weigh and risk and tweak where it can be tweaked. So, yes, it did. And I didn't know it was going to happen. My lawyer called me. They had a hearing. Was it oral argument? I assume the SSA was there to defend its decision. My lawyer called me and told me about it. But there's also corruption and denial rates. Past judges talk about it on YouTube. Keep in mind, some of them are trying to make a little penny on clickbait. But there probably is. Well, look up Eric Kahn case. I believe there were judges, lawyers, and doctors, all corrupt. And what was it for, Jen? It wasn't for denial rates. It was for false awards. So it goes both ways. When you're dealing with humans, we humans have a tendency to have a streak of deception and greed. And for some, it gets the better of them, and it usurps their morals and their values and everything else. I don't know. I will say also, there was a judge who got removed. I had him in a case, and he awarded my girl, and I was shocked. It was a one percenter, and I really didn't expect her to be awarded because she was a really different. She was a super person, but she wasn't really a good testifier, and she had one of those kind of cases that was like subjective. I knew she was disabled, but she would, she didn't want to do certain treatments. She would give the doctor what for, and she went very naturopathic kind of because everything triggered her symptoms. And this judge awarded, and I almost fell off my seat, and so did she. We both knew it was a tough case, and we were thrilled. A few months later, what happened? I got a letter saying, we're scheduling you for hearing. And I called up the hearing scheduler, and I said, what do you mean? We had a hearing. And it went quite well, actually. We didn't have a decision, by the way. The judge told, the indication on the record was that we were. And she said, I don't know, but he's not here, and all his cases have to be redone. I was like, shit. So we did have to go for another hearing, and interestingly, we did win. But that judge, what happened was, it turns out he had been awarding 100% of all claimants. And apparently not everybody is fully disabled, even though they think they are. You know, some people think, I'm used to doing this job. If I can't do this job, I should win. And they get denied because there's other jobs they can do, legitimately do. And they keep applying, and they have a right to a hearing, and they go, and they need to be denied. I think you would agree with me, right? They need to be denied if there's other work they can do. So that's kind of where it starts from, I guess. The rules are designed to make sure the people that can do other work, who are not in fact disabled from all work, don't prevail. And yeah, it gets really sticky. I don't envy judges their job. I would never want to be a judge. Back when I was younger, I thought, oh, how prestigious. That would be really cool. Heck no. I would not want to do that. I would not want to have that be the deciding factor, you know, because they can't pick and choose what cases come before them. Sympathetic, but cases that the guy really could do a different job, I just wouldn't want to. I wouldn't want to be there. Wouldn't want to be there. Wouldn't want to be president either, because that is a very difficult job too, and to make a lot of tough decisions. It's a hot one. It's a little warm in here. This jacket will be off in about 2 minutes. Wanted to address, it was an interesting question someone brought up, the perception that ALJs do not prefer pro se claimants. I don't know if that's true, but I will say a couple things that I hear about also, and maybe I embrace some of it. But the notion that an ALJ doesn't like a pro se claimant because they think they're better than them, or they are beneath them, I think would be totally false. I've never, you know, I don't necessarily like all the ALJs I meet, but I've never, ever met one that I got the impression that, as a general rule, they don't like claimants that are pro se because they are beneath them. I don't get the general rule, the general idea either, that they don't like claimants in general because they're beneath them. Not at all. Do sometimes I get the impression an ALJ doesn't like a claimant? Absolutely. I think it has more to do with perhaps, and I'm not saying they should ever show those feelings or make it evident on their face or their demeanor, but sometimes, being human, it happens. So we've all seen it. I think that might be more a reflection of their correct or incorrect interpretation of the evidence, and how it might be, in his mind, inconsistent with the claims made by the claimant. And that's just me thinking that's what I kind of think it might be. Pure, I mean, in a sense, it's speculation. I can't read someone's mind. So that would be what I would think about those rare instances when it seems apparent that there is some sort of disdain. Very, very rare. I promise you that people that get denied, they don't know it's coming based on an ALJ's demeanor, because they're generally extremely respectful, very kind, and bend over backwards. And that is true with a pro se claimant and a claimant with an attorney. They might razz the attorney a little bit, but you know, they're generally very, very kind to their claimants that come before them. So I appreciate that. And I think we all should. Now, what was the other question? Is there a presumption by an ALJ? And again, we're only going to speculate here, because you'd really have to ask the ALJs this, but I have a feeling this is the answer that we would find. Is there a presumption by an ALJ that a claimant is not disabled because he doesn't have representation, and he would have representation if he had good evidence of being disabled? I don't think that's true either. I think because so many representatives will not take the less favorable, in terms of winning a claim, vocational profile folks. For instance, representatives will not take people under 50. Some won't take them under 55. Some might take them in their late 40s, but not, you know, low 40s and below. The ALJs have, by and large, been doing this stuff a long time. And I think they realize they don't go into it thinking he doesn't have a representative, he must not be disabled or someone would have jumped on it. Not really true, because those young people, of which many get awarded, granted, many do not, but there are always ones that get awarded because they are provably disabled from being able to do any job full-time on a sustained basis, not just for one day, 1 week, or 1 month. So because they are not going to get the eyeballs from representatives, would-be representatives on them, because many just won't even take the time to look at them. I think the ALJs, I would expect, are fully aware that these people got short shrift really in review. Now, will many of them not be disabled because the rules are a little different and they don't have the maybe diminished ability to adjust to other work that would be based on their age and what happens? Generally, not all of us. I think, everyone knows statistically it's harder, but everyone also knows that there is sprinkled throughout that the masses of the younger folks, truly disabled people. So I would say, in my opinion, the ALJs give every young person case the same due process they would give an older person with a different vocational profile. And they would do the same represented or unrepresented. Yeah, for sure. And there would be no difference in treatment because someone is unrepresented, except if you're unrepresented, then there is someone perhaps not doing all the work that a representative would do, and the claimant sometimes doesn't know he or she is supposed to have done it. This is extremely common. A lot of you don't know that if you're going to be pro se, you better be ordering your records and sending them into the judge. If you're looking to get your doctor's extra opinion on something, you better go get it. If you believe you need a consultative examination, you can ask the judge for that, and it'll go to the DDS to set that up, but it'll still be in his jurisdiction, that case, heading towards trial. But if he thinks that, yeah, maybe you need a consultative examination on that, you could be the one to ask for it. It doesn't have to be his idea. I mean, he might say no, but you could definitely ask for it. And I wouldn't be surprised if you didn't have thorough evidence or treatment, I should say, about a particular impairment you have, and it may need, more recent follow-up. They might do a CE for that for you. I mean, I prefer you use your own doctor usually, but medical expert, all sorts of things that, you might not know you could do. The ALJ is going to do it. And they also, if you've noticed, some of you people have probably gotten forms from the ALJ. This is pre-hearing, asking for certain details about your work, like recent work, your current medications, and your current medical treatment since the appeals. They want to get up on top of it because there's many things they can do to help get that evidence if you haven't already sent it in. There are those hit mirrors we always talk about, and a lot of the major networks do that, and the SSA or the OHO, I'm not sure how it works, has an arrangement where, because you have provided your release smartly to them, the SSA HIPAA release, they can go and quickly gather your medical records from a particular health network that they have arrangements with, en masse, if you will, and electronically, so they get them, in real time, so to speak, when they make the request. So those are the things that the ALJ will be doing if you're not representative. Sometimes nowadays, to some extent, they're doing it when a person is representative, which is super kind because, for instance, the hit mirrors, we can't do those as lawyers. We can send out paper requests and hope that they comply within 30 days and get it back. That's the only way we can request records. Is it true that you have a patient portal, perhaps? Yes, and those are really helpful. But my firm understanding, and this is from an ALJ specifically, that those portal records lack, I already knew they weren't the full official set. They hold things back. But they also perhaps lack all the messages you may have sent to your provider through the portal. If you're one of those smart people that message them through the portal so it's documented, hint, hint, those might not be in there. So the hit mirrors, even by the ALJ, now we know they do that at the initial and recon stages, but at the ALJ, I think they're starting to do them now, I'm seeing. I don't know if it's required of them or if it's policy. I don't know if I just read that it might be, but anyway, we never really drop the ball on what we do for untried and true policies that the SSA is potentially bringing up, because if they fail on it, we're not taking the risk that our client has less than stellar set of records that would be available. But anyway, so the ALJs do more work if you're a pro se, I believe. They also perhaps may, well, at your hearing, obviously your representative isn't going to be asking any questions. So I would think at your hearing that the ALJ is going to be a little more, I don't want to say on the ball because they're always on the ball for the most part, but has to do all the question that he might have left for your representative. Now, the ALJ doesn't know your case like your representative would, so that's kind of not always going to bring out all the information that you would have wanted because the ALJ didn't know, right? He didn't know about your, conversations with your attorney that would have had your attorney bring out some questions and make clarifications to things that you have answered to the ALJ's questions at the hearing. So the ALJ has to be a little bit more protective of you to the extent he can, I believe, he or she, to bring out more details that your own representative would presumably, if they're doing their job, would have brought out at hearing, if not redundant or something useful, at least to get it on the record so that if you have to appeal, it's on the record. I should just add in that little aside there. Now you might wonder why this question or that question and why that's not my main thing. A lot of what we do when we're having hearings and even in preparation of documents you submitted through initial, through recon, etc., are not just for the moment's request in real time. They are also to protect for a future appeal should your case not work out with an ALJ. A lot of times if something, what you submit is going to be hanging with that case later. So you want to get it right the first time. So, doing it right the first time protects you on appeal later. I've even seen it protect people in a subsequent application. Strangely enough, I've seen the SSA on initial and recon drag up old reports from prior applications and stick it in the file. I suppose it's fair game. I mean, it's something that the person said, under penalty of perjury or, under oath, if you will. So, you just don't know. But when you are pro se, those clarifications of inconsistent statements probably will not be protectively provided you if you don't have a rep. But the ALJ might certainly be asking you about some of those too. So he has to really kind of do the full circle instead of having some of it done by the representative. So I think he's got a little bit more work to do when you're pro se. And knows that it might be under more scrutiny because you did not have the benefit of counsel either. So his or her duty to make sure you are fairly treated, while that should always be a duty, and I believe is, even with a rep, I think it really gets driven home when you don't have a rep. Okay, so that is my thoughts on ALJ feelings. And again, it's just purely my gut feeling on some of this stuff. And just generally speaking, and it's speculation, really. You'd have to ask an ALJ and probably ask all of them because they probably all have different feelings. They're all human, right? But in terms of feeling superior to a claimant, I don't think so. Could there be a rare exception due to something? Sure. Do they think there's something wrong with the claimant's case if he doesn't have a representative? I don't think so. I really don't think so. There are so many. Do you know how many times claimants don't have representatives because their mental state is so obnoxious due to mental illness that no one can tolerate them? It's not that unusual. I mean, for representatives to bow out of a difficult case with perhaps an abusive, mentally ill claimant if it gets to be too much. And so then that person's cruising into a hearing without a representative. And I think the judge already knows that there's an issue. If there's been a multitude of reps on that case, more than one certainly is going to be a little eyeball. Perhaps the person has interpersonal issues getting along with people, maybe anger management, maybe paranoia, oppositional type of behaviors, who knows? So they might see that, but it's not going to say that you have a worse case. That could actually, in some ways, that might be a better case. Anyway, it is all in the end going to rely on your evidence, your medical evidence in particular. So as we say, Check out the videos. Treat big and small impairments. Don't be riding your laurels on your big one because you're probably going to lose then. All right, guys. I'll talk to you later. Bye now.